All right, can everybody hear the court okay? All right,
Yes, Your Honor.
okay, let me go ahead and call the 245 matter. This is cause number DC 22-01388, the state of Texas versus Brittany Dawn Fitness LLC et al. May I have the parties to just briefly announce on the record for me. Let me know your name and who you represent in this action.
Good afternoon, Your Honor. James Holian for the plaintiff, state of Texas, and I'm joined by my colleague, Monica Wadley, also with the Attorney General's office and for plaintiff, state of Texas.
All right, thank you, counsel. Counsel for the defendant.
Good afternoon, Your Honor. Calvin McClain for defendants, Brittany Dawn Davis and Brittany Dawn Fitness LLC.
All right, thank you. I understand this is the plaintiff's motion for sanctions regarding some discovery issues. So, Mr. Holian, I think this is your motion. I will hear from you first, and then I'll give Mr. McLean an opportunity to respond.
Thank you, Your Honor. Your Honor, I'm going to start with the ask. The state is asking for the court to sanction defendants, Brittany Dawn Davis and Brittany Dawn Fitness LLC, for violating the discovery, the reasonable discovery propounded on them and the rules associated with, as well as this court's order in September 2022 requiring that they provide all their responsive documents and information. This request for sanctions is pursuant to Texas Rules Civil Procedure 215.2. And what I'm going to do, Your Honor, is go through some of the background briefly to explain factually why we believe that the sanctions that we're requesting are warranted in this case. So to just step back, Your Honor, for a moment, we've got big picture. The state filed its petition in last year, February 2022, in it seeking civil penalties, injunctive relief, attorney's fees, etc., for defendants' violations of the DTPA. In particular, we are alleging that defendants sold since 2013 online fitness and nutrition packages to thousands of consumers, and that they failed, and that in those packages were online coaching and individualized macronutrition assessments, and that was a foundational aspect of those programs that she promised to provide. We believe the evidence at this trial will show that she did not provide individualized macronutrient assessments to consumers, nor did she provide the promised coaching. And so, therefore, the state is considering these to be violations of the Deceptive Trade Practices Act. So that was in February. Later in February 2022, defendants filed their answer denying all of the allegations. In April 2022, the state sends its first request for interrogatories and first request for production of documents. After four requests for extension of time to respond to discovery, defendants failed to timely respond and served evasive and incomplete responses in June of 2022. In August of 2022, we had to file our motion to compel. The court had that hearing in early September 2022 and granted the state's motion and ordered that defendants provide complete responses to all discovery and provide all responsive documents by the end of the month. The court gave them, asked how much time they would need. They asked for 45 days. The court gave them until the end of the month. And we were happy to just have a firm deadline so we could move this case forward. Well, now the question becomes, Your Honor, what has happened since? So what has happened since is on that date, on September 30th, 2022, defendants served their third amended response to interrogatories. They also provided a document via email that was, the email itself was called missing information, and included a spreadsheet that supposedly represented all of the client information that was requested in the state's interrogatory 5 and 7. And to put just a bigger picture on it, the state's interrogatories 5 and 7 are really looking for key critical information in this case, for defendants to identify all of their consumers, who purchased these packages and how much they paid for these plans, as well as information about whether they, what month and year they purchased them. But by and large, the information requested in interrogatories 5 and 7 is who bought your products and how much did they pay for them and when. So in September of that very last day that the discovery was due, they served these responses. They also provided by the end of September over 52,747 documents. These documents were unorganized in a non-native format that required a very time-intensive review by the state. But talking specifically about the responses, I'm now going to talk about the 5 failures of defendants to adequately respond to discovery and to comply with this court's order. So I'll take the first area. The first failure was to respond with a proper identification of all of their consumers. The information we have obtained about all of their consumers is in several different areas of their discovery responses. So, and I'm going to point the court to the state's moving papers on pages 4 and 5 of 14. So in interrogatory number 5, defendants say that less than 2,100 persons purchased nutrition and fitness plans from the date the website started in 2013 to present. Now, they also, in that document I discussed earlier, that client spreadsheet, that was supposed to represent all the client information that wasn't provided. So that's actually an exhibit. That's Exhibit E to the state's moving papers. We have included that spreadsheet, but redacted the client information for client privacy purposes. But what that would show you, if you were to count all of those rows, is it would show you that approximately 1,638 consumers have been identified. So first and foremost, there's an inconsistency with the number of folks identified in the interrogatory response itself. And then on top of it, the fact that the spreadsheet identifies 1,638 people. And that was supposed to supplement or in some way respond to interrogatories 5 and 7. When we went through the document production, we went through all 5,300 pages and we had their client spreadsheet open alongside every document we looked at to see whether the names matched the people on the spreadsheet. We did that because, frankly, Your Honor, we were concerned we weren't given all of the information. And sure enough, we identified 575 additional persons simply from documents produced by defendants. That's no small difference. That's not 2 or 3 people that were inadvertently overlooked. That's a 35% increase in the amount of consumers that defendants had failed to identify in that original list. Another indication of defendants' failure to comply and respond adequately to discovery and comply with this court's order is with respect to the amount paid by each consumer. The sum total on the Exhibit E spreadsheet, the client spreadsheet provided by defendants that identifies those 1,638 consumers, comes out to a little over $169,000. If you add up all the plan costs for each of those consumers, you come up to around $169,000. On the other hand, defendants' PayPal records for the monies that were received for purchases made on the bdonfit.com website come out to nearly 1.6 million. That's the amount of money. It's 1.561727. Over 1.5 million was received into the account since it was opened in February 2013, which is significantly more than the 169,000 that defendants identified in their third amended responses. So these are verified responses under oath, and they are missing payment information for nearly 90% of the persons who purchased, the consumers who purchased products from defendants, 90%. So defendants have failed to respond to plaintiff's discovery request, which seeks that they identify all consumers who purchased their plans and all payments made to defendants. The third way that the defendants violated the court's order and failed to properly produce discovery is in the fact that they failed to provide documents reflecting the personalized macronutrient recommendations for each consumer. And I'll explain why that's really addressed on page 5 and 6 of our motion. So for example, in interrogatory number 9, defendants are asked to identify each consumer in interrogatory number 5. So again, number 5 is identify all your consumers who purchased a plan. Number 9 says, of those persons who purchased a plan that would have included individualized macronutrients, identify all of those who received them. Defendants answered under oath, all of them who were told that each consumer who was paid for a plan that included personalized macronutrient calculations and adjustments received them. And that's in Exhibit C to the state's motion. But however, defendants in their document production only produced personalized macronutrient calculations or adjustments for approximately 103 consumers, 103. So they're saying and remember, their numbers cannot be relied upon, but of the 1,625 consumers, according to defendant's third amended interrogatory response, would have received individualized macronutrients, they only provided those documents for 103, or roughly 6% of the numbers they've identified. Again, grossly deficient. The fourth failure of defendant's production has to do with coaching, and this is discussed on page 6 and page 7. So again, plaintiffs sought documents that would evidence that defendants coached the consumers that were promised in a 30, 60, 90, or 6-month plan that they would receive individual coaching. Nearly all of that coaching was to occur over email or text message. So we asked for those documents to be produced. In response to interrogatory number 10, defendants answer that each consumer, in other words, all of her consumers received the promised coaching if they followed the instructions. That's her response. So now in asking for documents that would support that, defendants only produced, of those 53,000 pages of material, only produced documents that would show check-ins or coaching related emails for 156 consumers. 156. That's 156 consumers of the over 2,000 consumers identified in either defendant's client spreadsheet or identified by plaintiffs in the document production, those additional 575 that we identified, meaning that's less than 7% of the consumers identified. And remember, Your Honor, we believe that this is just a small fraction of the total consumers. This probably, we can only estimate based on the payments of being 10% of the payments, that we're still talking about thousands more consumers. So a representative sample of 156 consumers is grossly inaccurate. So we can reliably say at this point the defendants failed to produce check-in or coaching related emails for over 90% of their consumers. Finally, the fifth way in which we believe that defendants' production is inadequate was simply that the evasive and inadequate discovery resulted in time-intensive review. 1/3 of the documents were duplicates. 90% dealt with refund data. So we had to look through 50,000 plus pages of material looking for this coaching information, looking for these check-ins, looking for this consumer identifying information. And instead we saw repeated requests for refund and refund responses that were not, that don't address the concerns that the state was seeking directly in its requested discovery. And it took going through the entirety of that production to learn that, which was a significant waste of time. So we believe, Your Honor, that defendants have provided only fractional responses of the number of consumers they've had, the amount of payments made to defendants for persons who purchase nutrition and fitness plans, documents that would show the personalized macronutrient recommendations or how those recommendations were determined. And finally, communications about consumer check-in or coaching. Quite simply, these discovery deficiencies, Your Honor, in the state's opinion, are so gross and significant to the state's ability to prove its case that it warrants this motion for sanctions, Your Honor. I will briefly address the legal authority. The Texas Supreme Court, Your Honor, says that for the purpose of discovery is to seek the truth. In this case, I'm going to point the court to one of the cases we cited, which is City of San Antonio versus Fulcher. And in that case, the court held that when a party conceals evidence that is detrimental to their case, an appropriate sanction is disallowing that party to offer evidence which contradicts or rebuts that non-disclosed evidence. And here, the concealed evidence would prove that defendant violated the DTPA. It would prove the scope of those violations. It would prove that she did not provide the one-on-one coaching and modify workouts or provide nutritional guidance to thousands of consumers. It would also prove that she violated the DTPA by providing individual macronutrient assessments when she provided essentially the same or didn't provide those assessments to consumers. These discovery responses would prove those allegations, and they would prove the scope of those allegations to the tune of thousands of consumers. And instead, we're given fractional pieces of information. And it's precisely for this reason that a party's hindrance of the discovery process justifies the presumption that defendants' claims lack merit. And if a party fails to produce material evidence, despite the imposition of lesser sanctions, the court may presume that the asserted defense lacks merit and dispose of it. And what we're seeking in this case, Your Honor, is to do that, is to say that the defendant should not be able to come up and testify at trial that she actually did provide this coaching, that she actually did do this individual macronutrient information when she has grossly failed to produce evidence that would indicate that. Your Honor, I would also like to briefly address the defendant's response, which was filed yesterday. I don't know if the court has received the response. We've also filed a reply this morning.
No, typically I prepare in advance of the hearing. So if you filed something last night and a response to that, it was not seen. I did read that motion. Let me ask you about one particular issue, Mr. Holland, before I hear from Mr. McLean.
Yes.
I want to know the sanctions that the state is requesting. Obviously, what I heard you to say is disallowing the defendant from offering evidence to refute the DTPA claim. Is that correct?
Yes, Your Honor.
Okay, and were there other asks in that in your motion for sanctions?
Yes, and Your Honor, in the proposed order and in the motion for sanctions, we lay out various versions under 215.2 that the court would have at its discretion to impose in this case. One would be to, one moment, Your Honor, I want to make sure I say this correctly. Under B3 of that section, the plaintiff would request that matters that for which the discovery order was made be taken as established. And we believe, Your Honor, that taken as established, as those facts would mean taken as established that the defendant violated the DTPA with respect to coaching and macronutrient assessments. Further, or as an alternative, plaintiff is requesting an order that defendants be precluded from opposing claims that defendants that precluding defendants from introducing materials about designated matters into evidence pursuant to B4. So, Your Honor, for example, on that, what we would have in mind would be if the plaintiff that the plaintiff is going to put forward that defendants violated the DTPA by failing to coach and failing to provide individual macronutrients for approximately 90+% of its clients and customers, that defendants should not be able to put contravening evidence on to those points and refute those points pursuant to this court's inherent authority under B4. And
let me ask you about that particular issue. So if the complaint is they didn't turn over what we needed to establish this claim, and you're asking this court as a sanction to preclude them from coming to trial to counter that, if they don't turn something over in discovery, they're not going to be able to use it at trial.
Correct, Your Honor. Although I'll add, and it's addressed in defendant's response, is they are now here at the last minute on an eve of a trial setting, alleging that the emails themselves were deleted from a server and that years worth of emails were deleted from a server. We don't want defendants to be able to make that type of refuting argument when, and I would address that briefly, Your Honor. We anticipate that defendant's counsel is going to tell you that the contents of his response motion would indicate that there is testimony from deponents in this case that would indicate that that somehow a server was deleted where the website was hosted in 2018, and that therefore the emails were deleted as well. What we've done in our reply brief, and I know Your Honor hasn't read it and wouldn't because it was filed today, but we actually provide the evidence of that testimony, and we provide documents that show screenshots from defendant's production showing that she has screenshots from emails of every year that she was in business, and these testifying witnesses, not one of them said conclusively that there was any emails deleted. The point with all of that, Your Honor, without going down a big long rabbit trail, is that we do think that what defendants are going to try to say now is we have an excuse for why we didn't produce those documents. And Your Honor, I don't want this trial to be a rehashing of a discovery issue in front of the jury for a day where we're trying to argue what was or wasn't produced. We want to nip that in the bud right now and say if they didn't produce it, they're not coming in and testifying at the trial in this matter with anything that would contradict the plaintiff's ask in this case, which is that they failed to, and more so than just produce the evidence, they failed to coach 90% of their consumers. They failed to, or more, frankly, given that they provided such an inadequate and incomplete picture of their overall consumer base. We're talking, by the time you consider all the thousands of consumers that should have been included, you're probably talking about 1%, if that. And so, Your Honor, we would argue that this case warrants a sanction that makes it very clear what defendants can and cannot do at the trial of this cause.
All right, Mr. McLean, the court will hear from you.
Thank you, Your Honor. And Your Honor, we filed a response yesterday afternoon. I understand it did not get to you. However, Your Honor, that response, it included two things. First, our client has produced everything within their custody and control. They have produced every document that they have at this point, Your Honor. Mr. Holian just stated that the witnesses did not conclusively. He qualified that answer as conclusively because each of the witnesses, two of the witnesses that he deposed did say indeed that a server from a web hosting company was lost. It was an exhibit in that deposition, in both depositions, that indicated the same. And I included a letter that was written in 2019, of course, 3 years before this suit was filed, that notified the state that documents were lost in a web hosting change. So our client can only produce what they have. What accounts for for duplicates or repeated documents. There was also testimony and depositions that around early 2019, when this all came to a head, when somebody started being very vocal online, that an effort was made to consolidate all files that were had in one place. And additionally, Your Honor, over time, emails, you can see from the production that emails were sent from one email box to another. And that may say why some documents were preserved and others were not. But it's definitely so that first, our client has produced everything in their custody and control. One. Number two, there is evidence that through a web hosting change, documents were lost for a period of time. And Your Honor, also one last point here. The state of Texas keeps talking about the number of consumers. It sounds like they likely have more information than our client does at this point, Your Honor. We notified them, and an attachment was on our response that our client was locked out of their PayPal account. They cannot access it. PayPal kicked them out. And we offered many months ago, and we spoke of this in the last hearing we had. All we want to do is produce everything that we have. We've offered to take our client's computer for inspection so they can verify she has produced everything she had. We also offered, Your Honor, to provide them email addresses and passwords so they can see, because we have nothing to hide. And I'd also like to finally point out that this was produced on 9/30/2022. If there was an interrogatory answer that was bad, it could have been raised well before today's date. The only notification that we had, we sent an email the same date that we produced on 9/30/22, and we indicated that they should have everything that our client has at that point. None of this was brought up until the day before they filed this motion. We never received a deficiency letter. And quite frankly, Your Honor, we believe that this is maybe a stunt to receive a continuance, but we're not sure. But our client, again, has produced everything within their custody and control, Your Honor, and the sanction is unwarranted for that reason.
All right, Mr. Holian, I'll give you final words.
Thank you, Your Honor. To just address some of those briefly, as far as the deficiencies in the interrogatory responses, it took reviewing 52,700 pages of material to know how deficient those responses were, which that review did not conclude until January of this year. We've got the holidays, a lot of material to get through. So the reasoning for the timing of the motion and the state's understanding of the gross deficiency of the interrogatory responses took what it took to get through the written material. And to address counsel's point about the idea that, emails or materials were deleted, I want to make it really clear for this court that what is undisputed in this case is that the defendant's web server for at least a short period of time was CBC Creative. And CBC Creative sent a letter to defendants in 2018 saying, basically, if you're not going to pay for our web hosting services anymore, you need to take your data and leave. Both witnesses who were testified acknowledged that the web hosting data, like the website itself, was deleted. Neither of them had any information that there was a single email that was ever deleted. And Your Honor, to be clear on that point, counsel in the response motion alludes to the idea that perhaps years worth of emails are deleted. We have provided in our response the actual testimony from those hearings as exhibits to show that that's in fact not what was said at all. And that is further supported by Exhibit C to plaintiff's reply, which has screenshots that were produced in discovery that show email chains in Gmail between defendants and clients in 2014, 2015, 2016, 2017, and 2018. In other words, all the years she was doing business, they produced screenshots that showed the documents. And further illuminating on the issues presented in this motion, those screenshots in Exhibit C, the actual emails, the underlying emails of those screenshots were not produced in discovery. There was the screenshot of an inbox that shows random consumer interaction, email threads, and say there'd be 5 or 6 email threads in a row on a screenshot of an inbox from all of those different years. But the actual emails that are in that inbox were not produced. That is precisely the type of discovery abuse that we're dealing with in this case, and that the plaintiffs are entitled to the requested sanctions.
All right. Mr. McLean, did you have something you wanted to offer? I am going to give the plaintiff the final word, but I know we're nearing our time. I do have another hearing that is awaiting.
Yes, Your Honor. The only other thing is that they complained about the format of the documents, and as native. Producing native documents is a challenge, even for certain professionals. Our client certainly was not able to provide native documents, but she did the best she can. And again, Your Honor, she has produced everything within her custody and control. There is no more that we have. And if they like to inspect anything to make certain, we again say we'll give it to them so they can confirm. And that's all we have, Your Honor. Thank you.
All right. Counsel for the plaintiff, I'll give you, if you need to respond to what you've heard, I can tell you that I am going to take a look at the defendant's response and your response that has been filed. Like I said, I did not have the benefit of those before this hearing. I've been in trial. And I will take a look at that, but I do plan to rule on this issue by tomorrow. There will be an order uploaded on Odyssey by the close of business tomorrow. So I need to make sure that I do have appropriate orders from both sides regarding this hearing.
Okay. Your Honor, I don't need to address that other than just to reassert that, we don't have a reliable client list. We don't have an accurate client list. We don't have accurate or reliable information about what clients paid for services. We don't have accurate information about the macronutrient assessments or the coaching for nearly all of her clients. Defendants should not be permitted to testify any differently at trial. Your Honor, with that, we will submit on our motion. If we could entertain the court's time for just another minute, I'd be curious about the status of readiness for trial next week and how this motion may or may not impact the court's willingness to consider a continuance, or for that matter.
It sounds like you are asking me what I will do if I'm presented with a motion for continuance, and that's not before the court right now. Okay. What is before the court is a motion for sanctions, and I will have a ruling on that for you all by tomorrow. In terms of whether or not you'll be reached for trial next week or whenever you all are set, the only thing I can tell you is to look on the court's docket sheet to see where you are in that particular taking order of being set for trial. And if you need to file a motion for continuance, then you need to go ahead and get one on file. But that's not before the court. And I'm not inclined to say I will do this if that.
Understood, Your Honor. And okay. And if I may, just another brief question of the court's sure. time. Will we be able to contact the court coordinator to determine, in other words, I'm trying to understand if my trial team needs to be up all weekend prepping, or whether or not, if we are the third to the bottom of the docket sheet, whether there'll be any indication from the court or the court staff after announcing ready about whether or not the likelihood of our case getting called.
I can tell you that the way that this court proceeds is pretty much how the procedures are in our Dallas County courts. So typically on Friday morning, we are calling those cases that are set for trial on, we're calling cases to trial on Monday. You've already got your notice of trial setting. We're basically calling on Friday morning to tell you, Mr. Holland, you're number 3 on the court's trial docket. Here's our pretrial instructions. This is what we are asking you to do and to be ready to do in person on Monday morning. Those announcements are made at that time. You can tell the coordinator we are ready to proceed to trial or we are not ready to proceed to trial. And if you tell her you're not ready to proceed to trial, she's going to ask the reason why, but still tell you to appear. And typically what happens based upon the order of the cases that I have in court, I'll know if number 1 is going. And if you happen to be number 3 and you're here and I'm telling you, hey, my number 1 is going and you are writing my trial docket until you might be called. So typically that is how we proceed here in Dallas County.
Okay.
But you should have an indication on Friday. But you should be able to go out there and take a look today as to where you are in the queue.
Right. One last question for you, Your Honor. What is the court's opinion on virtual testimony in a jury trial, in an in-person jury trial?
I can tell you the court has the capability of calling a particular witness via Zoom. That witness is live and the defendant would have the ability to, typically, if you're calling someone, it typically draws an objection because I don't have an opportunity to cross-examine them. But typically, the way that we have the technology set up here in my court is they appear live by Zoom. So there is an ability to cross-examine. I have done that if for some instance that person cannot appear in person, but those have been limited circumstances. I had an expert out in California. It was a wrongful death case and he was an economic damage expert, but he was older and concerned about his health and traveling because of COVID. And I did allow him to appear virtually via Zoom, but again, the other side did have the ability to cross-examine. So typically what happens, there is an iPad, which really just operates as a camera on plaintiff's desk, as plaintiff's counsel's table, as well as defendant's counsel's table. And then the particular person appearing virtually is on the big projector screen, which is right before the jury box. And there is a microphone that picks up my comments, plaintiff's comments, defense counsel comments. It's a 360 microphone and it picks everything up.
Thank you, Your Honor.
Okay, any other questions before I let you all go?
Yes, Your Honor.
Yes.
We did, and of course, I don't want to raise this at this point. It's just a timing issue on a untimely designated expert. I know it's 45 days to oppose it. With it being so late, could that be a morning of trial?
We'll take it up on pre-trial.
All right, thank you. Thank you.
All right. I will see you all at the next go around. Take care.
You.
Bye-bye. All right, counsel, give me just a moment to bring up your case.